Hello and welcome to the Rogers Brief for November 13th, 2022. I'm Adam Rogers. Thank you for watching and thank you for listening. This week I'm going to be covering news stories that are in the legal realm in Canadian law this week. And so I'm going to be covering four main things, which are first of all this week in the Emergencies Act Inquiry that's taking place in Ottawa. There's some developments in that story from this week. There was a decision from the Supreme Court of Canada on mandatory minimum sentences. This was a decision many were expecting that the Supreme Court was going to overturn mandatory minimum sentence provisions that were brought in during the Harper government. The Supreme Court of Canada did not do so, so I'll discuss that. Third thing I want to talk about is these two pieces of legislation before the Parliament in Ottawa dealing with online free speech and privacy legislation. These are bills C11 and C18. I'll talk about those. And then finally, there was a decision out of the Nova Scotia Court of Appeal in Preston was the name of the case. And what it involved was alleged sexual assault, a person convicted at trial, and one of the issue on appeal was whether the trial judge was able to use text messages that were sent after the fact, apologetic text messages. Well, are those admissible pieces of evidence? And so the court discussed those, and I'll raise that as well. Before that, I just wanted to talk about an idea I had germinating and see what people think, invite some feedback on this. Last week, I was talking with Jordan Bonaparte and Paul Palango on Jordan's podcast, the Nighttime podcast, and what we were talking about was this lawsuit that's been filed by Lisa Banfield, the spouse of Gabriel Wortman, the mass killer in Nova Scotia. And one of the issues that came up was Miss Banfield's lawyer, Brian Murphy, out of Moncton, and his website has Better Call Brian on it, which of course is a takeoff Better Call Saul, a television program that was a prequel to Breaking Bad. Saul Goodman, the lawyer, television lawyer. So I didn't think that was particularly professional to put on a lawyer's website. But anyway, so it goes. But the idea is all these other pop culture references. By the way, I've watched season 1 of Better Call Saul, most of it anyway, but not the whole series. As a lawyer, especially after you're practicing for a while, you tend not to watch so much legal drama, courtroom dramas, whether it's television shows or movies. But one of the reasons is you look at them and you're like, well, that would never happen. Lawyers don't do that. That's not how court works. That objection wouldn't have been treated that way. There's all kinds of things that, don't quite fit. And so it doesn't ruin things for you, but it just changes the way you look at television shows and movies. But what I thought about was, well, why not discuss some of those things? Everybody has their favorite, TV show, whether it's Better Call Saul or Law and Order, the old Jack McCoy days, or more modern versions of it. Law and Order, by the way, just a great example. You'd often see the prosecutors in the sort of the holding cell or the meeting room at the jail with one of the alleged criminals, and the prosecutor would be like, "All right, here's the deal, and this is this deal is good for exactly 5 seconds, and take it now." None of those things ever happen. The prosecutor wouldn't be talking directly to, an alleged criminal. These things would all be discussions among lawyers and so on. Anyway, so whether it's Law and Order, Suits, which I haven't watched, movies like A Few Good Men, The Firm, Michael Clayton, The Lincoln Lawyer, older TV shows, LA Law, which I used to watch a lot, and Matlock, these kinds of things, To Kill a Mockingbird, talk about those shows. So I'd be interested in hearing, what are your favorite lawyer-based TV shows, movies? Is it something where you have questions? Would that really happen? So invite those kind of comments. All right. So on to the stories and the four that I'm going to cover this week. The first one is the Emergencies Act Inquiry, which of course was sitting this week in Ottawa. Some drama this week involving one of the lawyers, but so we heard a little less about the Ottawa-based situation and more about Windsor, Ontario, where the Ambassador Bridge had also been the subject of a blockade, and Coutts, Alberta, which is a border town bordering Montana and the United States, of course, and there were some protests there as well. So we heard from we heard from a number in Alberta, including Marco Van Hugebas, Fort Macleod councillor. Fort Macleod, if anybody hasn't been through there in Alberta, a really nice little town, has a fort there. It looks like a nice wooden fort. But this was a councillor and a protester. He was actually charged with mischief. Didn't go into that very much in the hearings. Mischief above $5,000. Talking about how the protesters wanted to meet with the Prime Minister Trudeau, and there was over 1,000 vehicles at the Coutts, Alberta border crossing. For some days there early in February, between the 3rd and the 7th, what we heard was that traffic was able to get through, although very slowly, and there were some interruptions. And on February 8th, there was a full blockade, and the Canadian Border Services Agency suspended service at that border location. On the 14th of February, of course, the Emergencies Act, Federal Emergencies Act was imposed, arrests were made, and the blockade was dissipated at that point. There were some guns found. A little bit of a criminal element had infested the protests. And what the councillor from Fort Macleod said was that the message from the protests was lost. The message that had been centered on the vaccine mandates and these sorts of things got lost with the media coverage of it, focusing more on the criminal element. Whether that's a fair characterization, I guess we'll find out more evidence. But interestingly, from Alberta, there didn't seem to be a lot of federal support for the actions in Alberta. And an interesting point was communication was going back and forth. Alberta wanted tow trucks from Transport Canada, and they wanted the armed forces brought in to assist with breaking up the protests, towing away trucks. The federal government, in a draft response, so not official, but they put this response together, was that Alberta had its own legislative authority to deal with the protests themselves. In other words, they didn't need the federal legislation. They didn't need the Emergency Act specifically, which is what this inquiry is set to determine, whether that legislation was needed. Sounds like the federal government themselves were saying that in Alberta, at least, the legislation wasn't required. Okay, in Ontario then, so the other part of Ontario, we had Mario de Tomaso, who was the Deputy Solicitor General, just below the Solicitor General, Minister of Justice in Ontario. The evidence coming from Ontario seemed to be that the provincial emergency legislation and the declaration, which was made a few days ahead of the federal declaration, was more effective. They were able to fine the truckers. They were able to suspend their registration on the trucks, which would affect their insurance coverage. And so these financial impacts were able to, have some effectiveness ahead of the Emergency Act federally being enacted. The Ontario government, we learned also this week, didn't think that the protests posed a real safety risk, other than maybe some isolated incidents. And for them, Windsor, the Ambassador Bridge, the 600 million, I think, in daily trade going back and forth was a much bigger priority than anything was happening up in Ottawa. But okay, so we learned all of that. But what was really dramatic this week was that during the questioning, the lawyer for the commission, Gabriel Poliquin, collapsed. We saw this on video. That he was just asking questions. He was in the middle of an important piece of his line of questioning, and he just fell over and collapsed. Now, heard Afterwards, paramedics came. The lawyer was wheeled out on a stretcher, but was conscious, sitting upright, and seemed to be doing okay. I saw they tweeted out a day or two later that he was feeling better, thanked everybody for the well wishes. Okay, so we'll see why this happened, whether it was if it's a specific medical condition, we probably won't learn about it because we never learn about anybody's medical conditions because of privacy reasons. But I just wanted to make the point, I guess, that, a lawyer in this situation, if you're questioning a witness, if you're making submissions on an appeal or any kind of, important case, it's like studying for an exam and being ready for an exam. Lots of people, students will stay up all night to cram for an exam. They'll try to fit everything they can into their brains and be ready for the exam. It's the same as preparing for an important witness or an important submission or summation. You want to have everything right. You want to get all the details. But the most important thing you can do is be ready yourself. You have to be in the physical condition, the mental condition. So that means, you need to be mentally sharp at the time. At the time of the performance. The performance is your exam. The performance is the questioning of the witness, making your submissions. You have to be rested. You have to have proper food. You have to have the right energy in you so that you are in a position to be sharp when the time counts. Cramming, doing overnighters, all those things that are going to make you exhausted and not sharp and focused at the time, those are things you need to avoid. Not sure if that happened here or whether we'll learn that, but just something to think about for lawyers in that position. Okay, so that's the Emergency Act this week. Focus moved away from Ottawa into the other locations, which also saw protest activity. Okay, next story. And this was a case of an Ojibwe woman, 20-year-old Miss Sharma. Miss Sharma was facing financial difficulties and agreed to try to smuggle in 2 kilograms, just under 2 kilograms of cocaine into the Toronto airport. She took a flight and flew into Toronto, was caught, had been paid $20,000 to smuggle this into Canada, and was caught, put on trial, and sentenced to 18 months in jail. All right, so the issue was there was a mandatory minimum, in this case, which prevented the trial judge, from the sentencing judge, from considering a conditional sentence or house arrest. Normally, if a sentence is less than 2 years in length, then the judge is permitted to consider whether the person, instead of going to jail, can be sentenced to house arrest under strict conditions. Usually that's complete house arrest with maybe an hour, a few hours a week to go run errands, get groceries. Sometimes not, but usually exceptions are made just for medical appointments and emergencies, appointments with a lawyer, and that's it. Sometimes a religious service. Everybody all of a sudden gets religious once they get house arrest, and they want that extra few hours to go out on a Sunday to go to a service, but usually just an excuse to get out of the house. Anyway, that's a digression. In this case, the Harper government rules, legislation, Safer Streets and Communities Act, had made importation of drugs, in this case, subject to a mandatory minimum, and thus ineligible for a conditional sentence. Well, that challenge, so Ms. Sharma, her lawyers, challenged that provision up to the Supreme Court of Canada. The rule in this case was that if there was a maximum sentence of 14 years, a potential sentence of 14 years or more, then the case wasn't eligible for conditional sentence for house arrest. That was challenged at the Supreme Court of Canada. Supreme Court split on this 5-4, so a very narrow majority, but the majority says that it's not up to the courts to decide that. If society, through the legislation, through the government, decides that these offenses are so serious and so important that they deserve mandatory minimums, and there's no statistically identifiable disproportionate impact on a particular group. Of course, in this case, Ms. Sharma's Ojibwe, First Nations. There's, of course, the court recognized that there was over-incarceration of First Nations individuals throughout Canada, but there wasn't evidence brought forward that there was a disproportionate over-incarceration of First Nations, indigenous individuals in these circumstances, importing drugs into the country. So the Supreme Court of Canada declined to find that the legislation was a violation of charter rights, equality provisions, and so on. So what they said is it's not up to the courts in those situations, it's up to the legislator, to Parliament, to change or fix those laws. Now, I do know that and Justice Minister Lametti reacted to this, and there is a bill in Parliament, it's before the Senate currently, that would change those mandatory minimums and give more discretion, or give discretion back to the sentencing judges. Generally speaking, I guess I'd say, it is good to have discretion for the judges and have as much discretion as they can, I guess, because individual circumstances may justify a lesser sentence in some cases. But, if things are serious enough and the societal impacts are serious enough, the court in this case says we will defer to Parliament and their parliamentary wisdom. So that is the Sharma case. Some of these mandatory minimum sentences have been struck down, but this one this week was bucking that trend. All right, so third story. I've been reading up on some of these online free speech privacy legislation pieces that have been working their way through Parliament, and there's two of them. Bill C-11, the Digital Charter Implementation Act, talking about online streaming, and then the second one is C-18, which is the Online News Act. So I wanted to talk about these two together. C-11 is talking about online streaming legislation, and what the government tells us it's designed to do is allow CRTC, Canadian Radio and Telecommunications Commission, which regulates TV, radio content, all of these things, ensures Canadian content, regulates the internet in Canada, so that they would be enabled to regulate content, regulate streaming content in Canada, regulate what they call our programs. Now, what the government and the minister says is that this is designed only to capture broadcasters. So, an official broadcast, not user-generated programs like this one, like anybody that just posts content to a social media service. But what the legislation actually says is that CRTC would be able to regulate content uploaded to a social media service. Well, so that means anything. It can regulate programs. So programs under the legislation means anything with a commercial aspect, directly or indirectly. So if you're generating ad revenue through your content, that's a program. If you have subscribers and gaming subscription revenue, that's a program, and that can all be regulated. So that what they can do is CRTC will be able to mandate payments. So if you're gaining revenue through your streaming service, through your uploaded content, directly or indirectly, CRTC will be able to tax that and make you pay a portion of that to the government. Also, what they would be able to do is ensure that algorithms that show what kind of content comes up for users would prioritize Canadian content. Maybe that's good for Canadian, people that are generating content within Canada, but it's still, it artificially adjusts what people are seeing beyond what their normal algorithms would show them. So that's certainly going to make a change. The second part of this, and it's related, is this C18, which is the Online News Act. The design of this seems to be, okay, so when you post a Globe and Mail or a Saltwire article on Facebook, the news organization, CBC, CTV, they don't get any revenue from that being posted to Facebook, even though Facebook, LinkedIn, all these other services can generate ad revenue by the fact that all these links are posted on their social media platform. So what it seems to be designed to do is take that ad revenue from the social media platforms that are getting the news article, in a secondary fashion, but still benefiting from it, and turning that back over to to the news entities that are generating the news in the first place. So anybody that posts these articles are, I guess, feeding into that system. It's not a tax per se, because the revenue wouldn't be going back to the government. It would be going from, except if it's the CBC, it would be going from the social media platform to the news organization. It seems designed to have people go directly to the newspaper website, go to the news website itself, rather than social media. It's another way of supporting traditional media, in addition to what the government is already doing in terms of subsidies, which of course is a different issue, but that's come along in the last few years as well. There's a freedom of expression issue here, though, which is, so now perhaps, the news social media platforms may be less inclined to allow people to post news links, and so people who are currently trying to curate a certain image, all right, you have your LinkedIn profile. I'm going to post articles about my profession, or vaccine issues, or, fashion issues, whatever the person's issue, whatever image the person is trying to curate through linking to articles that cover that issue. Well, that expression, which is a recognized freedom of expression platform, I guess, is going to be restricted. So people won't be able to express themselves by posting links. So that is a restriction. It's a clear restriction, and it's based on this legislation. So that's C18. So on the one hand, you won't be able to curate the image you'd like to curate, and C11 is going to distort the market as to, on the one hand, C18 is going to limit what external links you'd be able to post to curate your own image, and then C11 is going to restrict and perhaps tax any content that you want to generate as original content that would further curate that image. So either way, the government is trying to either limit and or distort what people are posting. So both are restrictions and distortions of freedom, and so could be a concern for people that are posting things online. So things to watch for. Neither has passed through Parliament yet, and there may be still opportunities to speak out on that, and certainly to, if they are passed, see how they're being applied by the CRTC and by the government, and maybe something that the next government may want to change as time goes on. Okay, last article, or last thing I want to talk about is this case out of the Nova Scotia Court of Appeal. I was going to say the King versus Preston. So, Mr. Preston was a young guy, early 20s, convicted at trial of a sexual assault, intercourse involved, had contacted a former co-worker, they had an encounter, and the issue was not what happened, but whether what happened was consensual intercourse or not. Charged under Section 271 of the Criminal Code with sexual assault, was found guilty by Justice Josh Arnold, and sentenced to 2 years in jail and 2 years of probation. And so the issue was whether there was consent, and so there was differing evidence from the two. got together, had contacted each other, spoke over Snapchat, got together late at night, drove off to a secluded place, and things took place there, which only the two of them, of course, would be fully aware of. So the victim, the alleged victim, sent some text messages after this. This was in the middle of the night, 3 or 4 in the morning, to relatives of hers, phoned her aunt, very upset. But those weren't the text messages and communications at issue. She texted the Mr. Preston the next day and, was basically telling him, how could you do that? That was wrong. And he apologized over text messages, a series of text messages. And so the issue was, could those text messages be used to figure out who was the more credible witness? And Justice Arnold said yes, they could be used. The issue is, if you're trying to bolster your own credibility, it's possible to all right, well, if you say you were assaulted, then all of a sudden you text a bunch of people to say you were assaulted. And then you bring those up and say, hey, listen, I texted a bunch of people to say I was assaulted at the time, and I repeated it 10 different ways. That makes me more credible. Well, judges are told you're supposed to instruct juries to be cautious of that repetition does not enhance credibility. So there's a risk that those things would be misused. But in this case, the judge the Court of Appeal said that the judge was correct to treat them as admissions. Now, the appellant, Mr. Preston, had tried to say that, he had anxiety and his anxiety caused him to panic and falsely apologize because that's how he deals with stressful situations. Well, that wasn't seen to be credible by the trial judge, and the Court of Appeal didn't interfere with it. So anyway, that's just something. If in fact they were false apologies, and in fact that nothing had taken place, then Mr. Preston was very unwise to send those messages. It's just something, some people think, well, I'll just apologize and be done with it, and even if I didn't do anything wrong. Well, the lesson out of this case is, do not do that. If you are truly innocent and feel you're innocent, don't go apologizing for things and hoping things are just going to go away. It'll be used against you as an admission, as a formal admission of sorts. All right, so those are some things that I thought might be of interest this week. I'll be back next week to watch more of the Emergencies Act Inquiry, and other issues that are coming up in the news as well. I'm also reading, almost finished actually, Jane McMillan's very good book on Donald Marshall Jr., probably the most impactful individual litigant in Canadian history, in my opinion. But Miss McMillan was a partner of Mr. Donald Marshall Jr. for some time and wrote a really good book on that. And so reading that, I'll bring some of that to you next week, and other stories that are in the news. So thanks again for watching. Thanks for listening. Invite your feedback on these stories or anything else you might be interested in having me cover. All right, so thanks again, and we'll see you next time.